review.
Yes, I will be doing that.
Thank you. All right. So let's go to the first question for the audience participation portion of tonight's seance. What is a power imbalance? I'd love the smartest and best looking and most intelligent person in the room to define for us power imbalance. Can I have the second smartest and best looking person in the room? All right, Alan, I'll head off. Just tell us the answer then.
Well, what you're referring to is where one side has, I believe it's something to do with has access to either way more information that they can have a broader perspective, or they just have more influence on the result.
Yeah,
Or
who,
one
who else?
side believes they don't have any influence over the result, and they come in with a feeling that they have no power, and that helps manifest just that belief. So the power imbalances exist almost everywhere
Yeah.
in
Who
that
else?
regard.
You
I,
bet.
I
Who
think there's
else?
some real power imbalances, though. I
Of
mean,
course.
they
Yeah.
exist and they're hardwired.
Hmm.
Can you give an example of Jenny Ann?
Um, Sexuality.
Huh?
I think income, race, education.
Mhm.
I would add to the discussion of power imbalance that somebody's perception of increased power, that they use it to influence the other party's participation in an agreement or resolution, so that that other person of lesser power is not able to come to a fully informed voluntary agreement. They're being influenced or manipulated.
Yeah. Anyone else?
I like what Felicia just said. It comes down to personality a lot of times. Just when you get the two, perhaps introvert and um, someone that just wants to take over. And that often happens in mediations.
You bet. All right, number two, what are the types of power imbalances? I think you've done a pretty good job of laying some of them out. Another one that comes to mind is resource imbalance. I mean, Grandma sues Nike,
Hmm.
who has more resources, right? I mean, and so it comes out pretty much in every mediation. There's to some extent there's likely to be a power imbalance. Okay, so
Sam,
you're
there's a comment in the chat from
please.
Whatcom DRC, and she says, and systemic factors that disproportionately assign privilege based on a variety of factors: age, disability, religion, ethnicity or race, socioeconomic status, sexual orientation, indigenous heritage, national origin, and gender.
Yep. Physical size is another one. If, in in-person mediations where someone, is a foot and a half and 50 pounds bigger, that can be intimidating to folks.
Another one is ability to articulate or intelligence or access to experts.
Right? Right.
If I could add one factor is when people are represented by either attorneys or an organization is represented by a spokesperson, that person may have more power, but representing somebody or an organization with less power, or of course vice versa. So that it's a rather complicated equation at times.
You also got situations where one of the lawyers is fantastic and a walking corpus juris secundum on that area of the law, and the other has been out of law school 3 months and is just learning his, her, or their ropes going forward. So, and one's represented and the other's not represented. I mean, this is everywhere we face it. All right. So you're sitting there, you're
Also, a few different.
mediating.
Oh,
Excuse me, Billy or Lori.
sorry. it can also be different in different cultures. In some cultures, older people are considered powerful and wise, and in some cultures, they're considered out of it now.
See, I
And that
I like the culture that considers us wise.
I do too.
Do you? I think that's fair. That's fair.
But anyway, there are
But
cultural differences in power sometimes also.
absolutely. You got high context and low context conflict orientations that play out day in and day out. All right. So this I'd like to hear from each of you, shortly, if you so desire. Um, is you're mediating your typical mediation case, and there's a power imbalance, and it's a whatever type you most frequently encounter. You're there to you realize that on the moment of your realization that this is going on, instinctively, instinctually, what is the goal you're trying to accomplish in that moment? What are you trying to achieve? Yes, Leslie.
Well, I haven't heard, I don't think, the presence of coercion and control and manipulation and narcissism and game playing and things like that that come forth where perhaps it presents itself with one person's doing all the talking or and the other person doesn't feel like they really have a voice. And I think our job is to create space so the person without the voice can be heard or
Okay.
feel heard.
Okay. And those could be two different things, right? Uh, uh, who else? What is your goal when you come to that realization? There's a power imbalance here that's impacting the mediation. What's your goal? Well, how about by raise of hands? Is there anyone here that would do nothing? Just play with it?
Lori says each person feels safe to express themselves fully and honestly and respectfully.
Okay. So good. What do you want to accomplish when you realize there's this power imbalance that's impacting the mediation?
I want to
It's-
accomplish both parties having an equal voice, being heard equally, having equal, not meaning equal outcome. They can decide whatever outcome they want, but equal input into the outcome.
Okay. Jeannie, tell us a little bit more about your nice comment.
Well, I'm thinking about, so I do a lot of high conflict family stuff. And one of the things I'm really aware of are when I'm with a man and a woman, what kind of co-mediator I have. So there's something about that, especially if I'm looking also at the issues that folks have coming in and how they're feeling coming in. Um, Another thing I'm looking at is how money is talked about and used. Is it used in a threatening way? So it just depends on what their agenda is. What are the subject matter? What are the subject matters at hand that they're asking us to help them resolve? And within those subject matters, I think we're going to find the power differentiations because that's where the argument is, right? So where there's argument and conflict, there's a good chance there's going to be power differentiation stuff. So and then sometimes people just bring a personality in the room that is, dismantling or disassembling or overwhelming or something like that, and that in itself can really suck all the air and the power out of the room. So I think going in, we have to be aware, literally walking in the room, for one thing, be aware of what's going to happen and know what we're looking at going in. And the other thing is just, be aware and moment by moment trying to get a handle on where is the power differentiation and is there one? I mean, I've been in situations that are, you would think there would be a profound power differentiation, for instance, with one spouse being mentally ill, and there wasn't. So it's not always what we think it's going to be. Yeah.
Hmm. Who else?
There's another comment from Mia. She says, encourage the perceived more powerful person to acknowledge the humanity of the other person.
Okay. Last call on what you want to accomplish.
I was just going to say, Sam, this is a trick question because, inherently, what people are saying is they want to try to balance the imbalance in some way, and, to not neutralize it, but acknowledge it and try to even things out for maybe the disadvantaged party in a way so that whatever agreement is reached, if one can be reached, is fair and it's durable. It can actually be something they can do, and they're not just going to cave into the power and give things up that they shouldn't have to. So
The mere suggestion that I would offer up a trick question is absolutely accurate in every way, because I think as the discussion evolves, you'll see that, at least in the literature, and we'll see how we deal with it, there are different suggestions between okay to rectify procedural power imbalances, not okay to rectify substantive power imbalances. And then the question becomes, what do you do when there are key important social justice, equity, inclusion, diversity, everything on the table? Do the rules change? So let's continue on down the path, and this will get more refined as we go. So, what options do we have when we encounter one? One is do nothing. So far, I haven't heard anyone brave enough to say, I do nothing, absolutely nothing. Remember Sergeant Schultz and Hogan's here? I see nothing, absolutely nothing. But does anyone do nothing? Just let it play out. And look how many people are going to do something on this call, but who identified themselves as transformative or facilitative. So maybe he said, to provoke discussion only, that what do these words mean? You're facilitated, but by golly, we're going to rectify some power imbalances. So how do we do it? How do we do it? We decide we're going to do it, right, wrong, or indifferent. We decide we're going to do it. How do we do it? What's your favorite examples from the kind of work you do?
Well, I think for me, sometimes there's a history of not DV, but there's certain kinds of, there's some kinds of abuse that is on that continuum. And it goes both ways in terms of how they treat each other very poorly. And I think for me, what I've learned being a high conflict mediator is that I step into it and I say the true thing.
Mm-hmm.
And I don't avoid it. I just say the true thing the way it is, just what it is, and nothing more. And I feel like I've learned that when you just take away all the dressing and just say the true thing, it's just on the table, and then it's there for them to see and discuss.
So, Jenny Ann, do you consider yourself risk or conflict tolerant or conflict averse, just as a in your general being?
Oh, I'd say I'm conflict tolerant considering the people I sit with.
All right. And so I'm asking those who may not be
Yeah.
conflict tolerant, how does that sit with you? That's rhetorical. How does that sit with you to go in and just say, and I'm not suggesting this is how Jenny Ann does it, but just basically saying, hey, look, here's what's going on, A, B, C, D, E. And one side is probably going to say to themselves, wow, I love this mediator. They really get me. And the other side's going to say, oh, I see. You're taking the side of this actor or actress over there who's putting on a show for you to get on your good side. What's the matter for you? They say to you if they're Italian.
Well, surprisingly, I don't get that very often.
Okay, good.
Yeah, so that's why I believe in that, in the process of just saying the truth, say the true thing. Just
Mhm. And do you think they pick you because of your directness?
so the DRC picks me. So you'll have to ask them that.
Okay, okay.
I mean, they know I'm direct and they know I'm a child advocate. So that's true. I mean, that you said something that's true. Yeah.
Well, me saying something that's true is one in a row is my current record. So I'm just going to relish that moment for a second. All right, let's compare this. Let's compare this now.
Sam, hang on before you go on. Leslie
Please,
has her hand up.
please, Leslie, fire away.
Fire away. Well, I've done years of collaborative divorce work and about 25 years as an attorney, but 20 of those years as a mediator. And I always have this term in my head that a colleague of mine, long since retired, said about collaborative practice. And I think it applies equally to mediation, that it's not for sissies, meaning the conflict is right. We're in it. We have to be comfortable with conflict. We have to be able to face it head on. It's easy to package a case and, tie it all up in a neat, pretty bow and present it to a judge or a court commissioner and get a ruling. And sometimes your client doesn't even need to appear. But with mediation, it's front and center, and I think we have to lean in. And we're asking our clients to sign an agreement to mediate that calls for good faith and full disclosure. And so I think with leaning in, just as mediator Jeannie Ann described, we need to say what we see. We ask for transparency, say what we see, notice things, inquire. Like it seems to me I'm hearing a lot of talking from you, and I haven't heard from so and so yet. Can we maybe pause and hear from him or her, whatever the case may be? Just name it, right?
Yeah.
I think we can be the container for folks. So at the table in those moments, it's just a moment in time that we're with them, right? We don't, so we're just seeing them in those moments. That's not who they all are in their totality at all. I mean, I think we can be the container for their messiness in that moment, and it can give them some comfort. And I think it can be a kind of kindness, and they can feel and see that if we're able to relate that to them, eh?
Yep, you betcha. Well, let's segue a little bit. What is reality testing? Who can give us a definition of reality testing? Reality testing is when I ask an open-ended question, don't get participation, and then ask if my mic is working. That's, that's an example of reality testing. What's reality testing and how is it different from power imbalancing? Yes, Leslie.
I think with reality testing, you might be looking at something, for example, like logistics, like a parent comes in and they're wanting, they say, I want 50-50 time, I want equal residential time with my children. And reality testing may be to be curious about that. What does that look like for them? What about the soccer practices and the doctor's appointments and the getting to school and from school and homework and, all of that, like logistically, practically, is it all doable within work schedules and commute time and, all of those things? Just ask away, ask questions for them to examine. Does it work versus power imbalance and trying to strike that balance, I think is like we talked about earlier, building that safe container where people both, they both feel heard.
Other thoughts? What is reality testing?
I'll I'll go, Sam.
Please.
Um, yeah, when I'm reality testing, I'm trying to open someone's mind to think about outcomes that don't fit within their narrow, um, their perspective, their position. Try to maybe make them think that maybe their position isn't, you know, think about what might happen. What if? Have you thought about that? To shift them away from entrenched positions, I think.
Okay. Who else?
I think reality testing also is presenting questions with things that they may not have considered, and then make them make the determination of whether that's important to them or not.
Okay. So who else?
There are a few comments in the chat. Leslie says, reality testing, how is this going to work for you? And then Karen says, reality testing is asking the party or parties a question to help them determine how realistic their plan or assumption is while not giving them an answer or your opinion of an answer. And then I said, I see two kinds of reality testing questions. How is this going to work in reality? In other words, the logistics. And also, what do you think will happen if you don't resolve this here? What are the implications of not coming to agreement?
Okay.
And as Karen said, not giving them the answer. I don't have the answer.
Okay. So let's go back and let me try to take another uh, shot at framing up the discussion. How many of you do mediations that are in litigation, or if they don't resolve themselves, will end up in litigation in court? The show of hands. Okay, so a bunch of you. Okay. To what extent, if any, you're in a case and it's your 35th foreclosure case that year, and you know how they come out, how they end up coming out if they don't settle and don't get resolved itself, and you've got, and I'm exaggerating for effect, a big bad greedy bank against a family with limited resources and perhaps isn't familiar with the legal system. Maybe English isn't even their first language. Um, do you balance that power, or do you do something? And how do you do it? And then the follow-up question will be, or do you do reality testing, and how you do it? So, what? How do you balance the power there? We know what the law is. You know what the law is. You know what the outcomes have been because you've been mediating these foreclosure programs for your center for, better part of a year. What do you do? There's a power balance. We said we'd do something about them. No one said they would do nothing.
I asked them questions. Where can you find out the likely outcome? Who can you ask? What sources?
Mhm. All right. Yes, Lori, and then Alan.
I think one of the dilemmas in mediation is when you're I think of this mostly with parental plans. And one party thinks they're going to win, and but you're pretty darn sure they're not. And based on experience. And how do you convey that to them? The reality testing is really important there. But I think you have to be really careful in not just trying to convince them, no, don't go to court, you're not going to win. You can't just say that. But and you never know what the outcome might be. But I think that's a dilemma.
Okay. Alan and then Tom.
Well, as I was listening to this, and I'm listening to the power imbalance, and I think about it in a little bit different terms because I deal with people that are some indecisive and some their minds made up and they don't have any problem making decisions. And that, in a way, is a power imbalance problem. They may have a real good case, but they're not behind it. They haven't decided whether to commit to it or they're a little bit afraid. And so, in a situation with your foreclosure case, and we'll take two examples. One, they have a really good lawyer who's really experienced, worked with all of the, fought the big banks for a million years. And I might say something like this. Well, I know you're a little ambivalent about going forward, but you've got a lawyer who's really well experienced in this and he's willing to take on the bank. And so your choice here is whether you really want to sort of follow that path that your lawyer has kind of laid out for you. That would be something if, for example, he had a winning case, but he's got to get behind it and commit to it. And that to me, I would be helping the client realize the power they have to make a choice. But let's say the other side of that is they've got a lawyer with very little experience and a case they might lose. And the lawyer's pushing the case real hard, but, let's say having seen 35 of them in the last 3 weeks, it's a loser. 20 of them went to trial and, that position lost. I might say something like, well, I know you must be a little ambivalent, and I realize this is a real complicated legal case that they have a lot of experience in, and they're talking about that, and your lawyer readily admits, his expertise is elsewhere. You might want to consider what kind of settlement opportunities could be created here. So that's shifting power, that's empowering one side, it's dealing with those power imbalance, or what we're calling power imbalances, but it's helping people become more decisive or less decisive. And I see that as much a factor as just shifting the power. And so when I see that, I'm very comfortable in that role as a mediator, which is helping people make decisions and then finding out, well, what do you base your decisions on? What are your resources? How much do you want to devote to this? And I realized that when I would ask lawyers about that, I ask very easy questions for lawyers to answer at the beginning. I always start with, what are the strengths of your case, rather than what are you afraid of? So I get them to talk something about something positive before we get to the other side of the coin. And even just saying, what's the other side of the coin? That's a softer way. That's a softer way of asking, what does the other side say about this that you don't like to hear? And so anyway, I guess that's how I see this notion of the mediator interaction. And I find that that is easier. I have more room to play with when I'm meeting with them privately and shuttling back and forth. But when I'm not meeting with them privately and when I'm very openly, I will do something like say to them, well, let's you and I have a conversation that the other side's witnessing. That way I'll get the other side not to butt in with, interfere with my strategy by overriding it. And then I'll go to the other side and do the same thing and lock their eyes and say, and acknowledge that other people are witnessing this conversation we're having.
Sam, I believe Michael Dill is next, and then Karen's comment in the chat.
Actually, we have Tom, then Michael, and then Karen's comment in the chat. Tom, take it away.
Yes. My caucus. I have usually a come to Jesus with both sides, caucusing with them, as to what the other side may look like. What happens if you don't settle? What is what are the ramifications? What do you think they're thinking? When someone has the whole picture, the big picture shown to them, they have a tendency to be able to move from just being stuck on one side. They're more open to seeing what the whole picture. But caucusing, I think, is real important, especially when people get hung up or kind of stuck. Um, it's yeah.
Tom, when you have these come to Jesus moments with them during Hanukkah, do you say come to Yahweh as the
Oh,
term, just to be
oh,
seasonally appropriate?
only when I'm in Australia.
Perfect. Michael, you're up, buddy.
I think that at least the way I look at the foreclosure statute itself, is it's there to create a balance, a power balance, because it gives each party an opportunity to present, to have a voice. And we as mediators facilitate that. And so that's the way I look at the foreclosure statute. I think it was created for that very purpose. And as mediators, we're allowing that to happen by just letting them have their voice.
Yeah. In fact, from your perspective, I'm understanding you to say you're carrying out the purpose of the statute, so that makes it okay. Is that generally correct? Am I missing something?
Well, I guess it all depends on what you say is okay. Every situation is going to be different. And so you're going to go with a different way. But one of the things when you look at the certificate is depending on what happens, because that certificate says, was this successful? Did they come to an agreement? Did they come to a settlement? But one of the things too in there is there's a place to say, did the parties, and that's either party, mediate in good faith? And so the statute allows that to take place. Whereas without the statute, one side or the other, typically the unrepresented side, may not have a voice. They just go through the process of whatever happens because of perhaps having the knowledge and or the legal representation that the other party may not.
So, given that, then is it okay to help the unrepresented party by telling them what the statute says and telling them what arguments tend to prevail?
I don't know if that's my place as a mediator to do that, but what's nice about the statute is they come representative. That may mean that a party may not have an attorney, but they have to have a representative or they can't participate in the statute or the mediation. So I allow those to play out. Now, the question you may ask is, what do you have when a representative for one is not knowledgeable of the statute? Well, that happens quite a bit. And I think what you have to do there is then ask questions that hopefully allows the representative to represent their party in a way that's going to be just for all parties concerned, so they can hopefully come to a settlement.
Okay. I think Karen, you said, was next, Felicia. Is that correct?
Yes.
Karen, anything to add to your chat at 5:50?
No, I nothing beyond that really. Well, okay, I take that back. I think it's also helpful to sometimes just basic reflection is helpful if there's a really unbalanced thing seeming to happen to saying. So what you're saying is you're proposing XYZ and you're proposing ABC and that's helpful if they're driving towards something that looks like they might be agreeing on it reflecting um, the agreement or the tentative agreement and the logistics can be helpful for them to just sort of hear it in your voice as the facilitator and potentially have them kind of troubleshoot it on their own.
Great. Last call on this before we move on.
Me, I want to throw a question out there.
Fire.
My question is this, is balancing the power showing bias to the less powerful party? And that's a trick question.
So, and that's what I'm trying to get at. So I'm really helpful for that prompt. Is you're sitting there, you have a sense of fairness, justice, right, equity, justice, and you're sitting there and party B is getting clobbered during this mediation. Is it okay to do something about that from your perspective as a mediator, or not okay as a mediator? Alan says, yeah, it's okay to do it.
I'm saying that's why I don't like calling it power balance. I think power balancing is bad branding because if somebody on the other side, let's say the more powerful side, I know we all know what it looks like. But if somebody on the more powerful side says, well, you're shifting the power and you're really helping the other side way more than you're helping me, and I'm not even sure I like this mediation, I'm quick to respond. I'm helping that other side make a decision. If they don't make a decision, you ain't going anywhere with this case. It'll just lie here in the mud. And my job is to help each side make a decision. So I guess what I do, and now I haven't really thought a lot about this until this conversation, but I'm realizing that what you're calling power balancing, of course I do, but I don't call it power balancing. I call it helping people get to where they need to be or aiming for resolution at the highest level. I kind of, I don't even remember making a comment like this in the past. And I've made a lot of comments, but I'm making that realization. I've been sort of well retired for at least 2 or 3 years now, maybe even longer. And reflecting back on it, that's how I'm sort of looking at this whole conversation. I think we agree that there are a lot of things that we can do, but we run into problems if it seems to interfere with our neutrality or our perceived role as a mediator, or even as our how we perceive ourselves. Are we really helping the situation if we're helping, the utility company deal with the indigent, person whose lights just got turned off?
Right. So, Lori, I promise I'd get to you next. I saw that your hand was up, but this is where I've been hoping that we would go with this. In the literature, if there is a theme, it says it is okay to rectify procedural power imbalances, like one person talks more than the other, that sort of thing. One person is intimidated by the other, separate rooms, so the parties don't ever run into each other for safety, what have you. But they will say, for the reasons Alan just articulated, it's not okay, or maybe is it, to rectify substantive power imbalances because it impacts our impartiality. And then that leads to this sixth question, which I'll just raise and then get to Lori, is we assuage our guilt when we say, as mediators, I don't tell them anything. I simply ask them a question for them to arrive at their own conclusion. So the classic example is you're mediating a case and the unrepresented plaintiff has a breach of contract dispute with their contractor, and the plaintiff wants damages for pain and suffering and emotional distress. And that that's not available in the majority of breach of contract claims. So you don't say to that person, because we're mediators, we don't tell them anything. We don't say you can't get it, comma, Goomba. We say, have you had an opportunity to determine whether or not pain and suffering damages are available in a contract case? Well, why do we ask that question? Because we only ask it because we know the answer. And we know they're not thinking clearly about the answer. But we assuage our power balance feelings by saying we're just reality testing by asking a question. And let's develop that later. Linda, sorry, Lori, sorry for the delay. You're up.
Well, I guess I would say I don't feel I need to assuage my attention to power imbalance. I think it's my role to address power imbalance because
Including substantive ones?
what do you mean substantive?
Well, substantive one is you've got someone with a great case and a great lawyer and all the resources in the world, and the other side has equity on their side and fairness, and they have no power and they have no resources, and they're getting screwed, to use the technical legal term. That's a substantive power imbalance.
In the courtroom, there may remain a power imbalance, but in the mediated session, there should not. So my purpose as a mediator, part of it, is to be sure that people are feeling that they can speak the truth, speak honestly, speak respectfully, to bring constructive and civil conversation to improve their communication. So yeah, in the courtroom, there may be that terribly big power imbalance, but not in the mediation session.
So what you're describing, according to the literature, is rectifying process imbalances. Okay. It's when you are influencing the outcome in mediation because you believe one side deserves fairness, even though the outcome might be different in the courtroom. That's a substantive power imbalance in the literature. We can all define it any way we want to. Who
If I
else?
understand you correctly.
Go ahead. Please, Lori.
Now, if I understand you correctly, I think that's right, but I do believe that you can try to address this power imbalance in mediation. But part of that is the reality testing, which I think addresses what you're talking about with the substantive difference.
Good. Yeah. Anyone else before we move on? All right. Under the category of duh, here's just, a lot of this can be summarized in, the sense going back to, are you transformative, facilitative, and evaluative? And the vertical axis is the level of mediator ethical concerns from low at the bottom to high. And then as we go from the left, facilitate conversation, more, transformative and low ethical concerns. As we move up and become more and more evaluative on this chart, our ethics become more in play. And it becomes more, there's higher mediator concerns. And one of the things I've done over the years is represent mediators who've been called on the carpet. And the folks that tend to get in trouble, not that that's not defensible because of immunity statutes and what have you, is those people that violate confidentiality, which is not today's topic. But those people who start becoming more and more evaluative, they run the risk, as Alan was talking about, one side being very distressed if you're helping the least powerful side by giving them information they otherwise would not have available to it. All right. Let's go on and let's talk a little bit, translate this into
Sam, I wanted to point out there are a couple of comments in the chat, and there were two people who had their hands up. Ginny Ann is one of them. In the chat, Mia says, depending on the party, the conflict may be drawing a lot of resources, time, money, cognitive energy, etc., An offer that looks substantively unfair may become significantly more fair when considering the losses each party can cut by accepting settlement.
Great. Good comment.
And then Ginny had her head up, somebody else did, and I didn't catch who it was.
So one of the things I was thinking is, in my understanding of transformative mediation is one of the goals is to preserve the relationship. So we haven't talked about that at all in today, but there is a kind of mediation where that's out there. And I think the other thing is because I had a practice and I have friends that have practices that work in faith organizations where there is obviously working toward preserving the relationship, but there is a moral component, their perceived immoral component or a moral component that they both perceive that needs to be addressed. And so depending on what kind of mediation we're talking about, I think I just want to keep in mind, I just want everybody to keep in mind that in transformative relationships or mediation, oftentimes the goal can be to preserve relationship. And then that has to, in fact, go back to addressing the wrong or what perceive who the parties perceive who is wronged and who is not. So,
You betcha.
yeah.
Thanks for that. So we all are familiar with the WMA standards. There is the website link. The question is, are these guidelines or policies or law or what are they? When they say we should do that, does that create a standard of care for malpractice? Are you unethical if you decided that you shouldn't do that and you did something else? That's all subject for another conversation. But let's talk about the specific ones in the context of however you define it, rectifying power imbalances, reality testing. All of these things are done in the context of the WMA standards. So self-determination, these are just quick relevant highlights, not the whole thing. That's why I gave you these site to the web. Mediators provide information about the process, raise issues, and help parties explore options before them. So let's just think about that for a second. I asked you about would you raise an issue, factual or legal, that you saw that the parties didn't, or if one party saw and the other party didn't. And there is a fair amount of conversation, although it was widespread, as is usual in groups of us mediators, that they're not going to raise an issue if someone else didn't do it, be it a factual difference or a legal issue. But if they do it, they're going to do it with everyone. But this comment seems to provide that in our standards that we provide information about process, raise issues, and help parties explore the options before them. So just sit with that for a minute. Does it surprise you that it says it's okay that we can raise issues? Anyone find that interesting or inconsistent or what? Jenny?
Well, I'm thinking about high conflict parents. I remember I was working with two folks that were both worked in a religious organization and a big secret in the middle of the table. It took an hour for the secret to come out that in fact the child didn't belong to the father. And at that time, it took an hour. We were arguing about insurance, who should carry insurance and who shouldn't. It took an hour also to come out that the kid currently had had cancer in his brain. And it
Whoa.
was like so it's me asking these questions and questions and questions. So yeah, I mean, I think I did have to ask those hard questions. Clearly there was something there, and they were there to talk about that, but they couldn't do it themselves. They had all these rules that kept them from talking about it. And yet this child had a huge need for parents to carry insurance. You know what I'm saying? So that's the case that comes to me right away when we're talking about this kind of thing.
Yeah. No, it can be very heartfelt and difficult chances. And don't get me wrong, I'm not saying don't do any of this. I'm not saying do something or don't do something. I'm just saying let's talk about it and think about it, and then you make your own decisions.
Well, I think
Uh,
the other piece that's really important is sometimes we'll step in the room with high conflict folks, and we're talking about a big old mess, and we're talking about something that's incredibly, pending, important, that needs to be dealt with. So I, I think that's part of our work too, right? We are
yeah.
totally in the moment with these people in a big bowl of mess. And
Sometimes we have to be aggressive about the need for them to collaborate.
yeah, lovely. Like, I love the way you put that.
All right, let's talk about impartiality.
We
Because,
have
Alan,
two hands up. First is Tom,
okay,
then is Leslie.
call on them, please.
Tom.
Yes, I would say there's always larger issues than what they're speaking. And that's one of the reasons that they will hire myself as an example, because they know I'm going to look at the whole picture. And if they don't bring something up, I will bring it up because they want it to be one and done. They don't want to have another mediation because something wasn't brought up. So I will usually ask them or if or caucus with them or whatever, but I try to look at the big picture. Where they're not looking is maybe an area that they need to be looking.
Yeah. Leslie Ann.
I think one of the things that's really important when you are deciding whether to give information or not is whether it will honestly tip the balance from one side to the other. Two parties in front of me who ostensibly hated lawyers wanted to just come to mediation in their divorce situation, and it was obvious that there was going to need, obvious to me, of course, that there was going to be need to be a conversation about spousal maintenance. But neither party brought it up. Neither party even mentioned it. And so I didn't feel like I could give that information that says this is something you need to talk about, because immediately that would have been leaning toward the one party. So instead I sent them out and said, come back for a second session when you have had some legal counsel. Fortunately, both of these parties could afford that. But I think that is an ethical thing we have to think about when we have information that will immediately tip the balance.
Okay. Absolutely spot on as usual with these cafes. Impartiality, we all
I have
know.
a comment as well. Sorry to keep holding you up, Sam.
No, no,
Um,
go.
I had one once in which during the initial intake sessions, the a party expressed to me that he did not want to they had a written agreement that said that they would that 50% of everything of theirs is 50% of theirs each, and unless divorce. And during the intake conversation, when they were getting divorced, the gentleman expressed that he was not comfortable giving up 50% of everything he'd accumulated based upon that phrase in the agreement they had. And during the mediation, they came to agreement to split everything 50-50. And so I wanted to just touch base with him, and I did not do that in front of both parties. Before finalizing the agreement, I had a brief caucus and said, asked him reality testing questions. When we did our intake conversations, you said X, Y, and Z. What are your thoughts now? And anyway, his thoughts had changed over the course of things, which is fine. Of course, that's totally fine. But there's ways to do it. You can ask them something in caucus that would be putting them on the spot if you asked it with them together.
You betcha.
And then there's a comment in the chat from Karen. Karen says, I interpret mediators may provide information about the process to mean providing information about the mediation process.
Yeah, I think that first part is correct, but the second part that I'm highlighting here, raise issues. I think a reasonable reading of that is substantive issues. And if it's not, maybe we have to discuss that and get that clarified. Michael.
I think what we're talking about is an art. And as mediators, we have an art with regards to how we go about what we're talking about. Because we could turn it the other way. And as mediators, I don't think we want one party to give up the farm, in other words. I'll give you an example. I had a mediation recently where one of the parties was just frustrated. They were basically feeling the victim and they just wanted to give up. So they said, I would like to make an agreement and have it in writing where it says, I will pay all the expenses, all the bills. So what I did is I said, okay, could you tell us what kind of bills? What's that look like? Is that the everyday bills? Is that the medical bills? So I was doing some reality testing there. And in doing that, it came across that this party finally recognized that they didn't want to make that kind of written agreement. So I think that as mediators, we basically look at what's going on, present it in a way where we ask questions, not statements, but questions which will get down to the bottom of whether they really want to do that or not.
Well, and should they really want to do that when we are, giving them, changing their mind? But again, asking the question versus making a statement operationally, according to the literature, and certainly in my experience, has the same result. The people change what's going forward. Tom, you've been monopolizing this whole evening. It's now time for you to tell us and enlighten us as to the correct answers.
Are you talking about this Tom here?
Yeah, Tom. Yep.
No,
The
well,
good looking Tom.
Yeah, thanks. Two thoughts too. Number one is, a good obligation, and part of our, I think, role is to assess whether you want to help the clients figure out whether this is going to be sustainable. I mean, there are times when we've seen, and if it's not, so you're asking the kind of reality questions and clarifying questions to determine whether it's sustainable. I think the other issue right here is that and I've had a similar situation where the other party has said, I just want out. I just want it over. And the question is, is this mediable, and should I just withdraw?
Well, that's a good segue to the impartiality comment, and we don't need to belabor that anymore. But it does say if at the time the mediator is unable to conduct the process impartially, then we have to withdraw. So if it's so bad that we feel that we can't participate, it's pretty clear that we need to withdraw. Given the time, I'm going to bust through a few things here and hopefully bring us home on time because Felicia, out of her own pocket, is ordering DoorDash to your home of your choice of dinners. So if you could put in the chat your home address, a salad or soup, entree, and dessert, and what type of wine you would like. She will be doing that through her account momentarily. It's so nice of you. Thank you, Felicia. All right. Let's go on to the next one. I'm going to skip that. Conflicts of interest. A mediator shall disclose all actual and potential conflicts of interest reasonably known to the mediator. So what comes up in the literature on social justice cases are that if that we mediators find ourselves when our own personal politics or beliefs or sense of fairness get in the way, and we have this irresistible urge by balancing power or reality testing or by asking questions or making statements, whatever you want to call it, that may rise to the level of a conflict of interest. Duh, it's for each of us to make on these circumstances. But I will tell you, back in the day, in the early 90s, there was a fevered conversation at then Spider, now ACR, about whether or not racial discrimination cases should even be mediated. That was unfair in the process. So reasonable minds, different things. Clearly, under quality of process, we know and everyone agrees that there should be adequate opportunity for both parties to participate in discussions. That's a procedural power balance, and no one disagrees on that. The question is that I'm going to leave you with is where does it cross the line to rectifying substantive power imbalances that affect outcomes? Where does it cross the line, if at all? Okay. Obligations to the mediation process. Under this comment, it says mediators have an obligation to correct abuses. Well, many social justice power imbalance, substantive power balance issues are abuses. And one party is trying to address them and the other is not. What does the word correct abuses mean in the context of the other standards when it comes to social justice issues? So we're going to have a closing dance number here that will be choreographed. And that's why really the reason Felicia wanted to record this is so we could use it as compromise, given the dancing abilities I suspect at least the men have in the room. So I'm going to hear your closing thoughts du jour. Take home. If you want to promote social justice and access to justice, do you tell the parties and get their informed consent ahead of time, or do we just make our independent judgment? Look at all the diversity in the room as to the presenting questions I put forward, and then ask yourself, the results are going to be different depending on what kind of mediator you get. And if we don't, the mediation process outcomes can differ depending on that individual's desire to power. And is that okay? Okay. I'm going to end with a poem. There once was a mediator named Stan who had not an ethical plan. He said to his peers to move over, I'll try full disclosure. Informed consent he found was great. Now the parties can mediate. And I say that to you because what if the fix for this potential fuss, however we define it, if it's a fuss at all, is to not guess what we think the parties want of us in these situations that we have outlined, but ask them, if you can, in a pre-mediation session meeting or during the beginning of the mediation, questions like, hey, do you want legal information that neither party has raised, or one of you has raised and the other hasn't, or one of you has wrong and the other is correct? Do you want factual information from me under those same circumstances? What do you want me to do, if anything, when a party fails to raise a relevant factual issue or legal point? Do you want me to say something or not? To what extent, if any, do you want me to express opinions about the likely outcome? What should I do when one of you is about to accept a settlement that is not as good as the result they would likely get in court? Yes, I understand you want closure and to get this done, but is that going to be, as I think last time indicated, is that going to be sustainable? Are they going to regret their decision if not asked and moving forward? Finally, here is some information about these topics. It's in your handout, so you have it. And before I thank everyone, I'll open it up to, we have 3 or 4 minutes for each of us to enlighten the rest of us as to any closing thoughts or comments. And I hope you got your orders in to Felicia so that food arrives as soon as we end the meeting. Any other closing thoughts, comments?
So I'm thinking about a case I had where a woman was 14, forced married. She was a child bride. And they were there, when her kid was graduating from high school. Of course, they hated each other the whole time, and it was a disaster, the marriage. So obviously, there's issues of social justice, especially when the husband said, well, it's her fault. She shouldn't have gotten pregnant in the first place. I think she got pregnant and had the baby by the time she was 15. So at some point, there's social justice issues there for certain, and she was brought into another country and all kinds of awful shit. But and the other piece of that is that it's just common sense. That there's just a whole lot of immoral crap that has happened here. And here they are 10 years later sitting in front of you. So, I mean, I'm just thinking about, should I, what would the point be to say, you should know that I think child, bride, taking people across borders, children's, et cetera, trafficking is abhorring. And I think you're revolting. What's the point of that? Do you know what I'm saying? I mean, usually people are 10 years out and through and in the muck that they've created, and there's got to be all kinds of laws broken and immorality mixed in with all that, talking about social justice. But
So you
that's
mean,
where they are now.
yeah, so you mean revolting in the most non-judgmental sense of the term, right?
Yes, I'm being honest with you. I mean, what he did was revolting, but that's also logical. I mean, we would all say that, right?
You betcha.
Okay, so anyway, I mean, you bring up
Last
a lot of
call.
dilemmas inside of me. You're
There you
right.
have
I
it.
mean, that is my politics. It is my social justice, but that's what I sometimes sit at the table with, you know?
Yeah. And sometimes it helps one side and hurts the other. And then the question is, okay or not okay? And it's not, I'm not debating that. I'm
Yeah,
just
yeah.
suggesting that's what we have to think about. So a couple things, people asked about the questions I proposed to ask to the parties. And unfortunately, I did not include that in the PDF that's sent out. But what I will do tomorrow is I've got 15 questions that I tend to ask parties, because most of my mediations, the parties are represented, except for those public policy cases where they're open to the public and people aren't represented. That I ask in a pre-mediation session caucus or during the beginning of the mediation. It's really important to ask these questions ahead of time, because if you delay asking them, when you realize it's too late. Because if you say, if you can't say, so what should I do when one of you is about to accept a settlement that's not as good as you can get if you went to court? They're going to go, oh, is that me? I'd like to know if I, well, that's not me. You better not tell. You got to get these questions answered when you're not at the head of the ethical dilemma. Felicia, any
Sam, if
last
you would
words?
just provide them to me, I will send them out.
Perfect. I'll do that. So
Thank
go
you.
forth, do good, avoid evil, have a great holiday season, and enjoy your new year. I'm happy
Merry
to talk to
Christmas.
anyone who just call me up, send up a flare, but I prefer candy grams.
Happy
Take care.
holidays, everyone, and thank you so much, Sam.
Thank
So
you,
so, so
everyone.
thought-provoking. Yeah. Take care, everyone.